together. And if you do that, then you have to consider what the law says. That's where the law comes in and provides guidance about what the meaning of practical completion is in that context. So if we look at how the concept of practical completion and substantial completion to an extent has developed, we can go back to 1970, and we've got a case here of Jarvis and Sons and Westminster, and another case about incomplete works. And here, Justice Salmon stated that completion for practical purposes, allowing the employers to take possession of the works and to use them as intended. And this is where the idea of utility comes into play. And so it became a question of whether, once the works were at a stage where they could be used, they should be deemed to be practically complete. But there was another comment from Viscount Dilhorn in this particular judgment, where he went a bit further than that and said that completion of all the work to be completed is required. So the test for practical completion in around 1970 was actually quite a restrictive one. And because of those two almost inconsistent judgments there within the same judgment, comments from the two judges, you ended up with certain people interpreting practical completion as being a state where the works can be used, and others saying, well, according to Viscount Dilhorn, actually there must be completion of all the works to be completed, which doesn't leave much room for any defects or snagging or incomplete works at all. So overall, we started with a very much restrictive test in English law around 1970. When we get to 1981, we have another case here with H.W. Neville, Sunblest and William Press. And here, Judge Newey, who I will point out goes on to become Lord Justice Newey, who was one of the judges in the Court of Appeal decision in Mears, which we'll come back to. But he's very consistent in terms of his analysis, and no doubt aware of his old judgment in this case. But what he really developed in 1981 was a more flexible test of practical completion. And what he said in the judgment was that practical completion will not be prevented where the works have been completed free from patent defects, so that's defects that are evident in the work, other than ones to be ignored as trifling. So this use of trifling opened up really a can of worms, because again, like many descriptive adjective words, they can have different meanings to different people. So it became slightly subjective as to, well, what is trifling? But there can be no doubt that within this test, there's more flexibility about achieving practical completion. So by 1981, under English law, it could be said that your works are practically complete, even where you've got trifling patent defects. And that could be shrinkage or some scuffed paintwork or minor incomplete works potentially. And so what that effectively did is open up more discretion to those who were certifying, if there was a certifier. And there certainly would have been, by this time, the JCT contracts would have been in use since 1960 actually, but the 81 versions of the contract would have been prevalent and widely used. And so under those contracts, you've got this third-party independent certifier who will decide whether or not the works are practically complete, and that would be the contract administrator or the employer's agent or practice manager, whomever the parties decide would be certifier. And so that certifier will then have discretion to make a decision based upon the contract requirements, of course, starting with them, and then to consider whether the works have got to a point where they are practically complete, even though you may see that there are certain trifling patent defects within the works. And of course, the idea is that any of those trifling patent defects or latent defects could be rectified within the rectification period, or the defects liability period as it was then, and put right. And so you've got this extra buffer after practical completion up to the end of rectification, where the contractor has an implied license to return to site and ought to return to site to rectify any defects that are uncovered. From 1981, we then move on to 2007. And in this case, the Mariner International Hotels case, we have confirmation really of the flexible trifling concept. And the courts decided that works have been completed free from patent defects, other than ones which can be ignored as trifling, will be practically complete. So really we have a sort of set position now by 2007 that trifling matters can be existing on site and practical completion still achieved. So there's still that flexibility and of course the discretion, as I said, of the certifier to make a judgment on what is trifling and what's not. It's worth mentioning the Ruxley Electronics and Forsyth case as well, because this got a mention in the Court of Appeal judgment. And it was a case that we raised as solicitors acting for the landlord in the Mears case. And what we said in the Mears case is that this case is analogous, it's similar in the sense that the works actually in this case, although it was argued that they were defective, and in fact it was beyond doubt that the works were defective, but nonetheless the works were deemed to be substantially complete, was the phrase in this particular contract. And so this confirmed the idea, we said, that works could be practically complete while still defective. The key question was whether or not these defects were so severe or serious to take them above what's known as trifling. And if they were, then of course the argument would be that you haven't reached practical completion. So in this case, and it's quite a funny case really, a swimming pool was built by a builder. And they were supposed to build the swimming pool 7 feet 6 inches deep to allow the owner of the house to dive into his swimming pool, being a rather tall man. And the builder actually built the swimming pool 6 feet deep. He got the calculations completely wrong and built the pool. But there was nothing wrong with the pool in the normal sense. It just wasn't as deep as the client had wanted. And the client argued, well, first of all, he argued that it wasn't substantially complete. And he then said that he wanted damages to rebuild the swimming pool effectively to the correct depth. And that was obviously a significant amount of money. Now, the High Court in this case decided that actually he was wrong, that the swimming pool was substantially complete because it was a fully functioning swimming pool. It just happened to be shallower than had been specified. And of course, that was a breach of contract. The case was then appealed. And when it got higher in the courts decided that actually he wasn't entitled, this is the client, wasn't entitled to full damages to reinstate the swimming pool either, because that would be disproportionate. It would be crazy to dig up the entire swimming pool just for the sake of a few inches. And so the judges effectively said to him, you'll have to take more care when you're diving in your swimming pool. And we're only going to give you nominal damages. of course, the reality is probably that he wouldn't have dug up the swimming pool in any event as well, and that was taken into account. So you can see here in this case that the courts of England are more flexible about this concept of substantially complete in this context, which we argued in Mears and was accepted ultimately by the Court of Appeal, also applied to practical completion. Interestingly, if you look at what the case law construction textbooks said around the time of the before the case came before the courts, in this construction law edition, second edition 2016 book by Julian Bailey, he said works are physically complete or certified as complete, save for minor omissions or defects. So there's a new introduction there of omissions, not just trifling defects. And the works are otherwise reasonably capable of their intended purpose or use. So he's confirming the view in the case law, which was that the intended use was relevant. If there are patent defects in the work, so defects that were evident at practical completion, let's say, or at the time it was alleged to have achieved practical completion, that are not de minimis or minor points, practical completion will not have been achieved. So there's then a reference to de minimis, which is obviously a Latin phrase which means very minor. And that equates to effectively the trifling word that's used in the earlier judgments that we've been through. So we've got a slight progression there again, a combination of three things there really. You could have minor omissions, defects in the works, and that the works could be used for their intended purpose. But those defects could not be anything above something that's de minimis or minor or trifling, to use the wording in the case law. Looking at Keating, which is often considered the leading construction textbook, in the 10th edition, it stated the following: construction works can be practically complete, notwithstanding latent defects. It seemed like an obvious point, and it was certainly the Court of Appeal's view that this was obvious, that if you can't see the defects, then you can't consider them. So that would cover latent defects. Latent defects can obviously exist at practical completion. That's the whole point of the rectification period. Certificate of practical completion may not be issued if there are patent defects, may not. But remember, this is before the Mears case, and that's why the Mears case is so important and really did shape the law as it stands, because it developed that concept there. Practical completion means the completion of all of the works that has to be done. You'll recognise Viscount Dilhorne's words in there, and that's that more restrictive test, which I think we can now say has probably has been superseded now by the Court of Appeal judgment in Mears. There is discretion to certify practical completion where there's very minor de minimis items of work that are left incomplete, and that's still very much the case today. So where the defects are considered de minimis or minor. So let's look at the Mears case in a bit more detail then. So the facts were that Mears had entered into an agreement for lease with the landlord, Plymouth Knott Street Ltd, and who were our client, and they'd also entered into an agreement with the design and build contractor. That is, the landlord had entered into a design and build contract to have the works built. And Costplan Services South East Limited were the employer's agent under the building contract, and so they were responsible for certifying practical completion. And the idea was that the contractor would build these 2 blocks of student accommodation in Plymouth, 2 large blocks with over 100 flats within the 2 of them. And once the works were practically complete, and as long as they were practically complete within the set period in the agreement for lease, that Mears would then take the lease, and the lease was worth an annual rent of 1.67 million, and so therefore over 20 million pounds were at stake in terms of a 21-year lease. So those were the facts, and before practical completion was actually achieved, there was a process through which the employer was to go through with the tenant to notify them that practical completion was expected. And that's what we did as acting for the landlord. We began the process by notifying them that practical completion was about to be achieved. And then practical completion was then certified. But it was certified in the context of the following key clauses. The clauses here are taken from the agreement for lease. And as I said earlier, in order to determine whether the works are practically complete, one had to look at the provisions in the building contract and within the agreement for lease and piece them all together to understand what was required to achieve practical completion. Clause 13.72 said that if a certificate of practical completion had not been issued by the 18th of September 2018, which was a long stop date, then Mears could give notice to terminate. In other words, they could get out of the lease if practical completion wasn't achieved. And I think ultimately that's what they wanted. They wanted to walk away from the student accommodation market, I think, as a whole, was my view. And so the way of doing that was to argue that the works weren't practically complete. Clause 14.4 said that the issue or non-issue of certificate of practical completion was to be in the sole professional discretion of Costplan. And this was an important point in the case because we said that, well, the employer's agent have certified practical completion and it's within their sole professional discretion. So they've made the decision, they've made it reasonably, and therefore, whatever you may say about the works, ultimately that decision is binding. If it were wrong, then you'd have recourse against them, but you wouldn't be able to cancel, as it were, practical completion. And then clause 6.21 was the key clause because this became the central part of the debate from Mears about why they said we didn't reach practical completion. 6.21 prohibited the landlord from making any variations to the works which materially affected the size of the rooms. It stated that a reduction in size of more than 3% from the sizes shown in the contract drawings was deemed to be material. And the building contract used standard JCT definition of practical completion, which basically says the works are practically complete when certified as such. But the AFL had other references, including to the satisfaction of the qualitative standards in the contract. But Mears, rather than choosing a whole host of challenges to practical completion, chose one particular argument under clause 6.2.1. And they said, well, some of these rooms are more than 3% smaller than shown on the drawings. And as such, that is enough to prevent practical completion. So I, for my sins, spent many days down in Plymouth, walking up and down these blocks of apartments and measuring rooms and looking at various aspects of the rooms. And there was much debate about which drawings were to be used to actually compare the size of the rooms. One of the arguments was, in fact, that actually the drawings that were referred to in the contract were only planning drawings, and the dimensions on planning drawings could never be set in stone, given that this was a design and build contract. And for all of those of you that know enough about design and build will know that the design changes, the whole point of the design and build. And as the design changes and develops, so in turn would some of the internal sizes of the rooms. So there were arguments about that, but ultimately the question for the judge was, are some of the rooms smaller than stated on the drawings? And if so, does it prevent practical completion? So Mears alleged that some of them were smaller, and they actually, before practical completion was indeed certified, obtained an injunction from the High Court restraining the employer's agent from issuing practical completion until this point about the 3% rooms was decided. And the court granted that injunction and said, okay, we will delay this decision about practical completion until we decide whether or not this 3% issue is enough to prevent practical completion. They sought a declaration that on the proper construction of the AFL, any reduction in room sizes beyond 3% was a material breach of contract, which prevented practical completion from being certified. Our argument was that the landlord ultimately was obliged to build the works in accordance with the building contract, and that a change of size, rightly or wrongly, against the drawings of more than 3% was simply not enough in itself, that you had to show that the variation in room sizes made it something that was not trifling, was not de minimis, that actually impacted upon the use of the building. Because it was absurd to say that you would rebuild the entire building due to the fact that a room was perhaps 1 centimetre or even smaller than that, a micron too small. According to the 3% rule, it would make no commercial sense whatsoever. And it would also allow Mears to walk away from a £30 million lease over 21 years on the basis of a very, very small change in the scope. And so that was the argument that was put before the High Court. And Justice Waxman found in our favour. He agreed with us that ultimately the change in room sizes of 56 rooms, although it did exist, and it was ultimately negligible in most cases, that in fact it didn't matter, that he refused to grant the declaration sought that discrepancies in room sizes prevented practical completion, and he agreed that it would have been commercially absurd. And one of our most powerful arguments was the argument that the bin store, the rubbish bin collection point for the students, was a room in the basement, and that room was slightly smaller than as shown on the drawings. But the fact was, you could still get the bins in there. You could still put the rubbish bins in that room, enough for the students, and it could be used as a collection point for rubbish. Now, just because that one bin store, taking Mears' argument to the extreme, if that was the only room that was very, very slightly smaller than 3%, would it be right? Would it have been consistent with the intention of the parties that Mears could walk away from the entire agreement if the bin store was slightly too small? Well, of course, that would be absurd. And so that's what the judge decided, quite rightly so. And on that basis, it followed that the injunction was lifted and that practical completion was then deemed valid as it had been certified, or dated the 18th of September 18. And so at that point, we had a valid practical completion certificate. Mears weren't happy with that judgment, and so they sought permission to appeal, which was granted, and they went off to the Court of Appeal in March 2019. And in the Court of Appeal, the three judges, and we'll come on to the judgment in a moment, analysed whether or not this argument about the 3% threshold was enough to justify or to constitute a material and substantial breach to prevent practical completion. And if the appeal was successful, it would mean that Mears could then terminate the AFL, and that practical completion was obviously invalidly certified. In the Court of Appeal judgment, Lord Justice Coulson, with the leading judgment, set out their findings. Lord Justice Newey, who we mentioned earlier from the Neville and Press case, who established the beginnings of the flexible test, and Lord Justice Lewison. And all three judges unanimously took the same view as Justice Waxman and followed the flexible test. In other words, they agreed with our arguments on behalf of the landlord, and they found that the 3% challenge failed and that practical completion had been certified correctly. And Lord Justice Coulson suggested that such a breach of contract would not prevent practical completion, as this would be commercially unworkable if every departure from the contract drawings, regardless of the reason or the nature and extent of the non-compliance, had been regarded as a breach of contract preventing practical completion. Whether such a breach was so material as to preclude the issue of certificate of practical completion was a matter of fact and degree in each case. And that is the key part of the judgment. The question now in English law, when looking at whether or not works are practically complete, is to look at the fact and degree of any indiscretions or defects at that time. And if the fact and degree of these defects is so severe that it would prevent the intended use of the building, for example, well, then it's likely that it would prevent practical completion. And so Mears' request to terminate the agreement for lease would have been disproportionate. And in that sense, the Ruxley case about the swimming pool was analogous. It wasn't right to grant a full award of damages. They would just get a nominal amount of damages. And in that case, remember, the works, whilst the swimming pool was too shallow, were deemed to be substantially complete, and it was consistent with that decision as well. So this case is very, very important in terms of interpreting what practical completion means, and it developed the concepts of practical completion in English law and has clarified them to more of an extent. It's easier to recognise than to define, was one of the conclusions of Lord Justice Coulson. And of course, that is really a nod to the discretion of the certifier. Certifier will be intricately aware of all of the works as they develop, and will be able to look at the state of the works as at the time being claimed, it's being claimed that they are practically complete, and make that judgment. Secondly, where the works have been completed free from patent defects, other than ones to be ignored as trifling. And that's a preservation, obviously, of the law as it stood, and that flexible test that I identified earlier. So nothing's changed in that sense. You can still have patent defects at practical completion as long as they're trifling. And Lord Justice Coulson went on to say that there's no distinction between patent defects and outstanding works, which was one of the key arguments in this case as well. Practical completion can still be achieved despite both existing. So you can have outstanding works at practical completion in the same way as you can have patent defects, as long as they are trifling. The nature of the defect is a question of fact and degree, and the ability to use the building for its intended purpose is relevant to the issue of practical completion, but it's not determinative by itself. So one can look at the intended purpose, and if the intended purpose can be achieved, that's probably a good indicator that the works are practically complete, but it's not of itself determinative. Just because you can use it doesn't necessarily mean that it's practically complete. And the fact that a defect cannot be economically repaired or even remedied at all is irrelevant to practical completion. The fact that something can't be fixed, like the room sizes, without demolishing the building, of course, in theory. The fact that it can't be fixed within the constraints of the building itself did not mean that the building could still not be practically complete, because of the bin store analogy, the fact that one room was slightly too small did not prevent the use of the building or have any effect on the building whatsoever. So what do we think about this judgment, and how does it affect what we do in the future? Well, I certainly think that it was a welcome development in the law. There'd not been a case for 50 years in the Court of Appeal in relation to practical completion. So it was a pleasure and an honour to be involved in that case. In terms of the implications of the judgment, I think it can only be helpful to provide further guidance, and then in turn that ought to prevent or minimise future disputes around this area. But of course there will still be disputes in relation to this, because there's still the question of trifling, patent and fact and degree to be determined. But there's a better chance probably of parties being able to come to some form of agreement on the status of the works. So the contractual definition of practical completion is the starting point. And of course, this case was all about practical completion. It wasn't about substantial completion, and it wasn't about completion per se. And so practical completion is a very special phrase, and this case is really guidance in respect of that particular concept, if those words are used. It's worth noting that if, for example, you're working under an NEC contract, that doesn't talk about practical completion, and therefore arguably some of these principles here may not apply to the question of whether the works are complete under the NEC contract. The NEC contract says that the works are complete when they're free from defect, and then there'll be a question over what is a defect. But the idea of whether something is trifling or not is obviously relevant to the question of whether something is a defect that could prevent completion in that context. But this is very much about the phrase practical completion rather than others. But if in your contract you have, let's say, ideally you'd have a checklist of what is required to achieve practical completion, then and the contract goes further and says if any one of these prerequisite conditions are not met, then practical completion will not be achieved. If the contract clearly sets that out, then the reality is that that will be the test, and there will be no room for argument. If some of those requirements aren't satisfied, then I'm afraid practical completion won't be achieved. So don't underestimate the power of the wording in the contract. Most disputes that relate to practical completion actually turn on what the contract says and what the requirements are, and whether those requirements have been met. Preconditions for practical completion, in the absence of very clear words that say if these are not met, then you won't get practical completion. So provisions that say, well, you must, let's say it says you need to provide O&M manuals in the contract, but there's no link to practical completion. Some preconditions like that may not be enough to prevent practical completion. So certain preconditions will be relevant if they are expressly stated as such. Otherwise, they won't prevent practical completion. The contract really has to expressly state that they are preconditions to practical completion to really become relevant to that point. Certifiers obviously now have to be very careful in terms of certifying practical completion in the right circumstances. So they should be mindful of the intended purpose of the building and the principles of the Mears judgment, and to apply the fact and degree test. But they can also bear in mind that, of course, Whether defects can be remedied or not is not relevant, and ultimately, if some of the defects found are trifling, then that would be okay, but that would be a question of fact and degree, and so that's what they've got to really apply their mind to when certifying practical completion. So my suggestion for projects going forward is to have a very clear, upgraded definition of practical completion. And there should be some kind of statement of the intention of the use of the building, if that's not obvious. Even if it is obvious, it's worth adding to the contract so that in the context of practical completion, there can be a judgment made as to whether or not the defects alleged affect practical completion. So please get advice on the definition of your practical completion provisions, and I'd be happy to advise on that. The parties' intentions relating to the effects of defects and variations on practical completion should be expressed clearly. One of the morals of the Mears case was that the agreement for lease was not clear on the effect of building rooms more than 3% smaller than the drawings. It said that it was material in size, but it didn't go on to say, as Mears had hoped, would be decided by the courts, that would therefore mean that practical completion couldn't be achieved and they could walk away from the lease. And if that was their intention, then that would very much have to be spelt out in the agreement for lease or in the contract somewhere. So it's important, it's imperative from the outset that the requirements of the contract match the expectations of the parties. And so they need to be set out first. And please do take advice in relation to covering yourself as an employer or developer or as a main contractor even in relation to that point. If there are other agreements, such as the agreement for lease, they must be consistent. One of the problems created, again, in this Mears case was that there were references, for example, in the agreement for lease to meeting the qualitative standards. And the question then became, well, what did that mean? And which parts of the building contract did that relate to? And so consistency between documents that form part of a package of requirements is fundamentally important. Again, that's to do with advice, it's to do with due diligence, to do with drafting, which we can advise on. And you must look at in the context of this case. If we look at, by comparison, other forms of contract, the ICE talks about substantial completion. As I mentioned, the NEC talks about completion. And so really the crux of completion as a concept will vary quite significantly depending on the form of contract. And the starting point is always going to be what words are used in that particular contract, how has it been drafted, and only then really will questions relating to the Mears case and the common law interpretation of practical completion become relevant. Thank you all very much for listening. I hope that's been useful. I'm now going to turn over to questions, and I believe that Julie's going to help me out here and read out any questions, and then I will endeavour to answer them. Thank you very much.
Thanks, Ryland. That was great. We've had one question in, and it's for clarity because I know you've kind of expanded on your points towards the end now. But someone's asking stating that they assume this is for an unamended contract. If a contract is amended to say practical completion is when all works are complete to the specification, free of any defects or snags, regardless of how minor these may be, would the same de minimis / trifling test still be valid?
The short answer is no. As I mentioned, the wording in the contract is the starting point. And in that example that you've just read out, clearly the intention is that even if there are de minimis defects in the works, that will not prevent that will prevent practical completion. So every single last piece of work in that particular contract would have to be complete, I would say, and it would be down to obviously the certifier to ensure that that's happened. So you can see just by adding those few words that this whole test gets distorted and becomes a lot more restrictive. And so, you know, that's why this seminar and looking at the Mears case is very much in the context of the unamended. By unamended, what the person asking the question really is referring to the standard wording in the JCT. It wasn't quite standard in this case, but it didn't have such restrictive wording as you've just read out. And I think if it had had that wording, the outcome may have been different.
Okay, thank you. Someone else has stated or asked, assuming the plan drawings formed part of the employer's requirements, does this make them contractually binding and therefore exceeding of the 3% threshold? That means there was actually a breach of contract, which Mears could seek compensation for, albeit the variations were not significant enough to stop practical completion.
Yes, again, the answer there is I would agree with that, assuming that the planning drawing requirements were part of the ERs, that they were defined as the contract documents, and assuming that also that the court had properly decided that 56 rooms were too small, then there was a breach of contract. And I would agree with the question insofar as it was Mears, really, their case should have been that they were entitled to damages. And in fact, that was one of our arguments to say, yes, sure, you can get, let's say, by way of example, a reduction in the rent, possibly for some of those 56 rooms. I don't think a bin store that's slightly smaller would necessarily justify a reduction in rent. And there's always a question over a reduction in rent anyway. The example I always give is in a hotel. If you book a hotel room at a certain rate, you're not guaranteed a certain size room. You'd often get a room of all different sizes and shapes, and they tend to have their own quirks. And I think the same thing often applies with rental properties. And of course, we're still talking about student accommodation. We're not talking about a 5-star hotel. So I don't know what the listeners' student accommodation looked like, but I can tell you that mine certainly wasn't 5-star. And so I don't think it even had 1 star. And so I think that ultimately the question's right. I think Mears should have been looking for some kind of damages. Instead, what they were arguing was that just because there was a breach, in some cases a very small reduction in room sizes, that automatically meant that they could challenge practical completion and furthermore walk away from the lease. And unfortunately, that was a step too far, I think, in the argument, and that's why they lost.
Okay, that's great. Thank you for that. So that's both questions that we've had come in answered. So if anyone has any more questions, now is the time to ask, or forever hold your peace. But I think you've covered all the bits and pieces on there. So as we said earlier, if you've got any questions directly for Ryland that you either didn't want to ask this morning or occurred to you as soon as we're finished, please feel free to email him on rylandash@silverllp.com, and he'll always be happy to answer these. In the meantime, we hope to see you again soon. Our next seminar is tomorrow evening, Hot Topics with Richard Silver, covering letters of intent. And the video of this, in case you wish to go back over it, will be available sometime later today. So we'll see you all again soon. Thank you, Ryland, very much.
I think it's fair to say the seminar's practically complete. Thank you, Julie.
Thanks, Ryland. Bye.